As I explained last week, what I want to do from this week is to go through the set of questionnaires, the legal questions that any foreign investor would be interested before they decide to make an investment into Korea. The background, the set of assumptions in the situation that this investment that we are talking about would be a situation where a foreign investor is interested in making an investment to create a joint venture, okay? Joint venture with a Korean company. Usually, in that set of joint venture situation, there could be many situations, but what that foreign investor wants is to create from the other side, what the Korean company wants is that two parties meet together and create a synergy so that it's better off, right, for each of them to be creating that joint venture and creating that synergy, because 1 + 1 is greater than 2, right? So what does the local Korean party has a strength of? I mean, the local party usually has an experience in Korean business. So what they have is that they have the local knowledge, how to do the marketing, what the consumer wants, how to promote this product, and how to go about dealing with all sorts of government agencies and all other things that are required. In other words, they know the market, right? Whereas the foreign investor has this great product that Korea does not have. It's got its own brand, which is internationally known and famous, and that it would make sense it would obviously want to expand into the the Korean territory. So those situations together is a perfect situation where both of them expects to create a synergy. So in this situation as well, we assume that there's a foreign investor who has a product who is interested in expanding into Korea, whereas the Korean party has and knows the market, has the distribution and other aspects where it can distribute and sell and market the product to the consumers. So, and then they will be better off creating a joint venture than not doing it, right? One of the reasons why foreign investor wants to test it through a local, for example, distributor, by appointing a distributor, just let them just do it through distribution. One way is just do it without creating any presence. Just sell you the product and you be in charge of distribution. But if you are more interested in permanently entering into, then another way that you could think about is a type of joint venture with the Korean party, right? So afterwards, if that joint venture just continues to be successful, if the marriage continues to be fruitful, then you go along. But happen to be at some point of time that both parties decide to part, okay? Then by that time probably the foreign party may have enough knowledge and resources and other things that they can perhaps start doing their own things by creating a subsidiary, et cetera, right? But then this is a joint venture. So a agreement that we are going to study is a joint venture agreement. But before we do anything, I mean, we have to think about why people enter into a contract. What is a contract? What is the basic philosophy behind contract? Why are, for example, why are government interested in enforcing a contract? Okay, this is a fundamental question. Why should a nation create a court system and be involved in disputes okay, over the contract which was entered into by two private parties voluntarily, why do they care, right, about what is right and what is wrong? Who has the right and who has the obligation? Who did wrong, and thereby get the proper remedies, okay, under the contract. So why do government care? It's because of this fundamental principle that human beings as a group, okay, it's social beings. Humans are social animals, and they belong to a group, and within the group there are exchanges, okay? So in exchange of the thing is that if I got A and if you got B, and I would like to have some of your A's and you'd like to have some of my B's, we want to do it because from my perspective, giving one of my A's and getting one of your B, I am better off having your B than just A's, right? Same thing for you. So what in this law of exchange means is that people enter into a contract because both of them feel that I will be better off by entering into a contract. This is a perfect situation of synergy, right? Where 1 + 1 becomes more than 2, right? By entering into contract, meaning I will exchange whatever resources that I have with whatever you got. Okay, you're going to supply me something and I'm going to pay you, etc., etc. Okay, it all makes sense because I believe it's better off for me and you believe it's better off for you, right? So in that creation of synergy, right, what happens if a party defaults under a contract, and why do they default? If the contract, for example, is a simple exchange, okay? We call it 물물교환, right? Simple exchange. Here is my orange, and you gave me your apple. Done deal, right? There hardly will be any problem with that because you already made the exchange right there. The problem with contract becomes real because we are not talking about something that you have can be exchanged right now. It's about the future performances you are talking about. You supply me certain materials and I will pay you certain amount that I agreed upon. When the two parties enter into that contract, both entered into because what? Because it was beneficial for them to enter into, to exchange at that rate, right? Then not. What happens about the future performances that as time passes, situation change, right? Maybe the price of material falls down or something globally or whatever. And then this one party feels now it seems like I'm paying too much for it. You know, I entered into at 90, now the price is 80. Okay? Maybe I can get it from other suppliers for 80 now. Why should I honor my contract? Okay, this becomes a problem, isn't it? Something happens that their expectation changes because of the variations of the situation changes over time. There might be some new supplier comes in, maybe some other people, whatever that comes in makes it become more expensive. The supplier who agreed to supply suddenly became, some situation changes and becomes more expensive and so on. So with various of those things happens because everything changes over time, then they have an incentive not to honor the contract. In that case, the state feels it's important for the wealth of the nation, okay? Obviously, as a government, you're interested in strengthening your nation, right? As a politician, that's what it is. You create this nation who has a better economic resources and all other things get together. They want the stronger and more, really a better nation, right? So obviously the government is interested in honoring the contract. In other words, it's a private enterprise, but you want to enforce it, okay, through this government intervention because they think this is critically important. If you do not honor people's promises, contracts, then obviously the contract would not become that important because everybody, if situation changes, can just simply renege it. In the old time, that was self-enforced. Think about it. If you are tribal kind of there's a various tribes and tribes kind of, made promises to exchange something when the time comes that failed to exchange. What happened? Then that tribe would go with their army of, small army and begin to enforce it by themselves. Okay? So nations recognize that it is extremely important to enforce the contract because only by doing that, right, people would trust the system, make reliance of the system and feel more free to enter into a contract. And overall, even though their expectation changes, entering into more contracts means people are keep on creating and trying to create the synergies without which, okay, you are worse off, right? So as a nation, you are really, it is tremendously important, okay, to favor an environment where people have exchanges, okay? And people have more exchanges knowing that the government will protect if they are wronged by the other party, all right? So that's the whole thing. That is why we have a court system, okay? And then now the court system moves into a little bit different area. Nowadays, we have alternative dispute resolution, right? You call it ADR, 그치? Alternate dispute resolution, which is basically arbitration. 중재, okay? Okay, what is arbitration? Arbitration is simply saying that, okay, we private parties entered into a contract based upon our negotiation without the help of any government, without any intervention of the government. Now we want to resolve our dispute, okay, through private means. Okay? And why is it becoming? For various reasons. I mean, sometimes the court system takes too much time because you usually have this appeals process where you could go appeal to the appellate court and then appeal one more time to the Supreme Court, right? Sometimes you want to keep that dispute really private between the parties. That's one big reason, right? You don't want other people to know. By going to court, for example, in the United States, if you sue someone, that's a public knowledge. That becomes a public knowledge, all right? You want to keep this matter private. You want to do it efficiently, and you want to select, and you go to the court, you don't have a choice over the judge. Okay? The judge may not be an expert in this matter, but you want to select those people who you think, you trust, have an expertise enough that they can make a more efficient manner. The the government recognizes that by having a law, okay, that supports such a system, right? So basically, what we call a arbitration act in Korea, 중재법, means basically what we are agreeing to do is that they are agreeing, the government is saying, okay, we will recognize, the court will recognize the decisions made by arbitration, okay? And we are ready to enforce it because what? Arbitrators can decide, okay, who should, whose remedy, whether the remedy should be granted or not, if the remedy is granted, how much it should be granted, etc., but they do not have a power to enforce it because they are not of the government, they're private parties. If I did not obey whatever arbitrary decision decides, then what they do? What arbitrators can do? They cannot enforce it by force, right? So what this system does is that what the arbitration law basically is, okay, we will recognize the award as the final res judicata, decision, meaning that final unappealable decision, okay? It's no longer appealable, right? So we will recognize arbitral decision as such, and we will enforce it, okay? And then they are having this, okay, but since it's a private decision, we have to take into account of some public policy issues, such as whether the service was done properly, whether recognizing such arbitral decision is not against the public policy of Korea, okay? Obviously, arbitration decision where the arbitrators decided that, okay, you need to pay this guy you promised, but he promised because he was threatened. Okay, let's say it's a duress situation. If it is done, if it's a duress situation, that obviously that agreement is not to be honored because it's just special circumstances, isn't it? So, in that kind of, if arbitrator decided you should honor this contract despite duress, then that would be a situation where the court will decide against, because that's against the public policy. But other than such extreme situations, all right, okay, making decision on, for example, some kind of gambling, that's against public policy, right? In those kind of situations, the court will recognize, the law says the court will recognize, court has to recognize and enforce it as if it was non-appealable final court decision. Okay, a decision becomes non-appealable, final. Let's say you have a most lower district court decision, and the parties can appeal within certain given time. If they do not appeal, then you lose the power to appeal, right? Then becomes final. If you appeal, then you go to the higher court. You go to higher court, and the decision was made, and then you have this time to appeal, right? Whoever disagrees, okay, we'll give you one more chance, all the way to the Supreme Court in Korea. Once the Supreme Court comes out, that's it. That's final, right? So that's a final decision. Either it can become final either through going all the way and have the final decision, or you just accept it, or for various reasons do not make an appeal within the given time, and it becomes final. But that's what arbitration is all about, basically. But there are rules, detailed laws that you should be aware of, but that's what basically arbitration is all about. So enforcing the contract is very important because it is indeed a key aspect of the wealth of nation, so-called, right? So that's why when foreign investors, before they are making investment, they want to know, before they enter into a contract, they want to know how responsive a court, how responsive generally the court of that jurisdiction. Okay, if I want to kind of take the dispute cases into the court, right? How responsive are they? Are they really going to honor, even though I'm from a foreign country? Are they going to favor their own country, the company that is their own, or are they, despite of that, they want to be fair, okay, and stick to the rules of the contract? How are they going to enforce? It's a critical question. Now, if I'm a company, if I'm a Korean company wants to invest, I'm surely want to know what it's like. So more developed you are, all right, in generally speaking, a country that is developed, sophisticated, has a well-developed judicial system, which runs under a fair system. In other words, they have a better system, more advanced system, where people can rely upon that system, right? So it is important for Korea to have such a system where the Korean courts are ready to honor the contract and ready to provide remedies to those parties, whoever they are, and wronged, if they are wronged under the contract, if the other party breaches, so on and so on. And Korea is generally known to be a very efficient system, all right? And they have the laws of the contract, which are similar to the advanced, what the more advanced nations are used to have. If the system is totally unfamiliar, then obviously you'd have a certain kind of reserves in making, relying upon the contractual law. So you got two things: the court and the governing law. If the governing law is, what's the governing law? There are two ways of designating governing law. One is by agreeing on the contractual governing law. That could be the laws of New York, for example. But despite whatever things that we do in creating a Korean joint venture, all right, there are certain type of laws that will mandatorily apply to a Korean company. Korean corporation law, which is under Korean Commercial Code, right? There are many provisions in that, Korean Commercial Code that are mandatorily applicable. If you are a joint stock company, 주식회사, okay, if you have a minimum capital, okay, paid in capital of more than 1 billion Korean won, okay, then you are required to have 3 directors and 1 statutory auditor. Okay, that's the rule. That's the rule. Whether under New York law, we don't care about New York law, okay? Because this is Korea, this is a Korean company, and you should have it, right? Under Korean system, a director has to be a person. It cannot be a corporation, right? But under certain other jurisdictions, yeah, corporate directorship is possible. They got different things, but it will nevertheless apply. So that's why they're interested in what aspects of law that will apply to the joint venture and creation of the joint venture and operation of the joint venture. So they want to know those background. Okay, so therefore, this is the kind of background where a foreign company would like to have some sort of preliminary questions. And this, in fact, is a set of good questions, because if you were an investor making investment into a foreign country, you'd like to ask these questions as well. Okay? And then, when you are a recipient of this question, you are a Korean joint venture partner, and you happen to work for that company, right, as an in-house lawyer, right, then even though you cannot answer all these questions by yourself, at least if you know why the foreign investor is asking this question, right, it will be very helpful. Even whether you try to do your own research or whether you want the research to be done by outside counsel, knowing where the scope of these questions, where these questions are coming from makes a huge difference. You understand what I'm talking about, right? So that's what we want to do. So you receive this set of questions, okay? And then you want to take a look at it. At least you want to know what those issues are, what these guys are referring to. You want to have a general answer so that you have this relative power to decide what to do in an efficient way, okay? Thereby, you are being considered to be a very good and efficient person to have. So, okay, so that's the general background, all right? So, if you take a look at a set of questions by topics, they want to know about foreign investment and foreign exchange control. Okay, that's number one. Number two is they have a question about what type of entity they should create for the joint venture and what kind of corporate governance that joint venture should have. Now, those are all, Korean law questions, right? Mostly would be answered by Korean Commercial Code. And then number three is industrial regulation. What applicable industrial regulations are there? For the product that we are intending, okay, to sell in your country, and we are creating this joint venture, what does the applicable regulation? For example, if it's a health product, what kind of regulation that would apply, all right? And then obviously interested in tax questions. And number five is an antitrust issue. Now, tax would be very relevant to any type of operations, right? So you can understand. But what about, okay, foreign investment procedures, those foreign exchange regulations will be obviously applicable because now you want to make an investment, right? And you will send US dollars or other foreign currencies into Korea. You want to know what regulations, what report are there that I should do because I'm interested in investing in this money to creation of a company and then get whatever profits out of, either by dividends, 그치? Either by dividend or other distribution that is made out of if the company makes money, right? Can I readily have that? Second, when I sell my shares, right? When I really liquidate my investment through selling my shares or through the really liquidation of the company, dissolution of the company, okay? 청산, okay? And then sell all the assets and then take my part, all right? Can I readily do that? So that's an important aspect about that they will ask, and this is not a surprise. Industrial regulation, yeah. What type of regulation you guys have in, do I have to make a registration for this product when this product comes in? What needs to do? What's the relevant government agency? Is it Ministry of Food and Drug Safety? Okay. Very relevant. How about then, what type of entity that should be created? Are you going to create, in Korea, there are a number of ways of creating different legal entities. 주식회사, 유한회사, right? 유한 책임회사. Then there is a 한명회사 and there's something else, right? Okay? So there's a partnership, there's a limited liability companies. We have two different type of limited liability company called 유한회사 and then 유한 책임회사. Okay? Then there is partnership. Okay? One is general partnership and the other is just limited partnership, where limited partners are not really liable, but the general partners are. So different type of legal entities are there. What kind of legal entity would be suitable, right? So then when that decision is made, what kind of corporate governance should be taken? If there's a 50-50, okay, if it's a joint venture between 50-50 owners, then you want to have equal kind of a equal ownership. Therefore, it should be co-managed. But how the structure of co-management should be done? Are we going to manage, for example, are we going to have two representative directors, one appointed by the foreign party and the other one appointed by the Korean party? Two representative directors, two 대표이사, right? Then how is it going to, who's going to make the decisions? Who's going to represent the company? Is it going to be the several or is it going to be joint? You know? So if there's only one representative director, if I take the role of CEO, representative director, then what should I do, the other guy? Okay? I should control the finances. I should be the money controller. Okay? So there is that, you know, CEO, then I take CFO, and et cetera, et cetera. All those kind of things. What about other executives? Okay? Who should take the statutory auditor? Is it to be jointly appointed? Each one appoints one. There should be two statutory auditors. What's the role of statutory auditors? Statutory auditor means 감사, right, in Korea. We call it statutory auditor because if we just say auditor, then they somehow get confused with the external auditor, external financial auditors like PwC or, you know, whatever. So it's statutorily required internal auditor whose role is not the same as the financial auditor, so we call it statutory auditor, right? So who's gonna appoint that? What about other types of management? How about the board? If the board is the ultimate responsibility of managing this company, okay, how many board members should we have? Should we have 2-2 because, or 3-3, equal numbers? What about we cannot make the decision because boards are split? Are we going to have even numbers or are we going to have odd numbers? Who's going to have a casting vote, obviously, in such a situation? Is casting vote allowed? You know, and so on and so on. All about these matters, obviously of the interest. But why all of a sudden this antitrust issues come up? Why is there a category for antitrust? So we got like five categories, and last category is antitrust. And what's their question here? There are many aspects about antitrust, right? But here, will the incorporation of the JV and the transfer of the existing business of the Korean party trigger the antitrust filing under the monopoly regulation and fair trade law and other relevant laws in Korea? If so, what are the major antitrust clearing procedures and the estimated time frame? So what they are asking is the filing requirement, so-called, in Korea called business combination report. What does a business combination report mean? In Korean, what does it call? 기업 결합 신고, exactly. Okay? So, 기업 결합 신고, business combination report. What does that mean? What are they, okay. What are we reporting about? So when the parties do something together, right? Like joining in a joint venture or some things of that sort, or I am acquiring a certain percentage of shares of you, right? Now you are mixing your interest now, right? The term antitrust means it's anti, okay? I'm against. What's a trust? Trust is getting together. It's a collusion, okay? We are afraid that the parties, look at the title of this law. It's anti what? It's the monopoly regulation, okay? Meaning I am going to regulate as a government, as a policy, we are going to regulate monopoly. 한국말로 뭐라? In Korean, what is it? What is it called? This law? 독점 규제, right? 독점 규제. So we need to regulate this tendency to become a monopoly, meaning a tendency to really concentrate the power and exercise such a power in an unfair way, right? Because of your market dominance, because of your power, or getting together with another strong party to even create more stronger party to benefit themselves would not be great. As a group, as a whole, right? There always is this tendency in any kind of a group. Within the group, there is always a competition too, right? So basically, that competition leads each one to be better off, to be succeed, and so on and so on. But while doing it, you're losing something. You're losing the kind of a possibility of that trust and tie and helping each other and those type of things, right? So extreme competition, right, is against the group to stick together. Okay, in order for the group to stick together, that means the group shares some kind of ideologies together. They want to help. There's an aspect about sacrifice. There's an aspect about care, and there's an aspect about love, right? Those kind of things, right? So whenever those things becomes really lacking, then within the group, there is no consolidating power. So when that group is competing against the other group, you'd lose, all right? So this is the rule this is a basic fundamental rules about this group is this. Within the group, the selfish being, right? A selfish being can overcome the nice one. You're ruthlessly selfish, okay? Okay? You can overcome. However, as a group of selfish people can never overcome the group of nice people. There's a strange paradox there. So that is why within this human being, you as a self, right? If you think yourself as a self, right? There is that tendency, always there's that dichotomy, seems to be, that in order to survive, then I have to be ruthless. In a way, I have to overcome, I have to win, and so on and so on. But at the same time, you're losing. Okay, as a group, you are losing something. So that's what I'm saying. So within that group, becoming monopoly, there's a tendency to become a monopoly. Tendency to keep on grow. If you look at a corporation, it's the same kind. Well, it's the nature of the reflection of human nature. Okay, so a corporation wants to. What does they do? They have to report. They go listed. They have to earn more money because if your earning become false, then their investors are terrified. They need to talk to the all these securities analysts and so on and so on. They are always earning kind of a earnings and earnings and earnings, better performance and better performance, etc., etc., etc. CEOs has to change if you underperform, right? Okay, and so on and so on. Okay, the board members will go if they, ultimately, that if you do not do well. So there is that tendency to grow in power, expand, grow, and become better and more powerful. Obviously, there's that tendency. So, given uncontrolled, right, then they will begin to collude. The stronger ones become stronger. But in a sense, it weakens the group as a together, right? It may be that particular person, particular corporation might become strong. It weakens the overall morale, so weakens the nation. Because that's the philosophy behind this monopoly regulation, right? Our nation as a group will become weak if we let this monopoly control. We're going to regulate. So every time you do something where you exchange your promises with the others, if that promise is something significant, okay, if your control becomes meaningful, so, under Korean law, right, the rule is there's a monetary threshold. If the company, one has 20 billion won and, and the other party has a 200 billion won annual turnover, meaning annual, right, annual revenue, okay? And between those companies, if you are acquiring shares, if you acquire more than 20% or more, then the reporting requirement triggers, and so on and so on. If it's between Korean party and foreign party, they're the same thing. And when you analyze it, you just don't analyze by that entity alone. You usually analyze the entity and its affiliate, meaning control. You are an entity, then there is this guy who is controlling you, and there are parties, there are other entities that are controlled by you. Then there are other sister companies where it is under common control with this ultimate parent. All these grouped together, okay? Then they talk about that, we calculate the turnover based on that group concept. Why? Because they are, in fact, exerting influence upon one another, right? So there are rules about a reporting requirement. Once that reporting requirement is triggered, you have to file a report, right? You have to file a report called business combination report. To where? To which entity? Which government agency do we file? Which is Korea Fair Trade Commission. Okay, Fair Trade Commission, but Korea. So Korea Fair Trade Commission is the English name. So you file it to the Korea Fair Trade Commission. Usually the time, if you are talking about if one is over really big, 2 trillion, then you have to file it before actually entering into that transaction. Meaning, if you agree to enter into a creation of the joint venture, then you have to file after the signing of the agreement, because before signing there's no agreement, right? No binding agreement. So after signing, you have to file it. And you cannot close that deal. You cannot create that joint venture unless you get clearance from the Korea Fair Trade Commission. They will review, okay, whether these are having a market concentration effect, whether you guys creating this joint venture company together will create the concentration of the market. Okay, they will analyze that situation and they will give you usually a clearance. If there's no market concentration effect is expected, then usually within 30 days they give you clearance. Failure to obtain that clearance means you cannot. So that's why these days any sizable company is concerned. Because why? Because this practically could apply in any type of business combination that even takes place outside of Korea. If as a group, as a whole, okay, if this guy A, there's a guy B, if their group as a whole has some kind of revenue generation from Korea, for example. Okay? Even though the matter is totally different, but nevertheless, if that revenue generation exceeds certain minimum amount, then that could be triggered, right? So that means if a joint venture is created into Korea, it's not going to just affect Korea. If A has a presence in China, A has a presence in Japan, okay? So does B. This Korean party might be a multi-corporation who has businesses outside of Korea. It can have in the United States, Europe somewhere, okay? Then we virtually could create a possibility where a number of jurisdictions need to file this business combination report. So it becomes a critically important, especially if your companies are big. Okay, this becomes one of the major issues. That's why this Department of Antitrust is keep on growing, one of the reasons. Not only that, the Fair Trade Commission in Korea is exercising a lot of influences, a lot of watchdog influences here. Okay, so they do a lot of where do you abuse your power? Basically, is the question that they're asking, and they take pride because they seems to be the one really active regulator who is regulating the behavior. Meaning that if the human behavior is left unchecked, then there's a lot of possibility that it's gonna go wrong, as demonstrated by the recent financial crisis. There's always that, there's always that kind of that different argument going against heavy regulation, going against the government, roles of government as the regulator, or versus just free market. The market will create efficiency. You leave them alone, and so on and so on. But as recently demonstrated, either can go wrong. We can see a situation where you put too much regulation into something, which makes it really difficult, unpredictable, and so on. Then obviously that will discourage people, to do something that might be regulated in that way, right? Thereby creating inefficiency. Okay, there's clearly over-regulation. There could be, but there could be a under-regulation. The role of government, I think United States being smart, which I consider smart, is when they created their government, they created a system of check and balances. Because knowing that if one party has that power concentrated and there is no check and balance system left in place, it is likely, will corrupt. Because there's nobody saying anything. So they didn't trust. Okay? Rather, they knowing the human nature, to power to gain the social status, and thereby once you gain it, if there's no checks and balances, in other words, if that system is not available, then it could go wrong, right? So that's why they created kind of tripartite government where each one supposed to regulate, supposed to watch you over and to check and balance the executive system, legislative system. The court says this one, I think it's smart because they recognize human nature in that way. All right, that's a rational choices. Again, here under any type of system, even under a religious kind of a system, if the authority has a power, if the pastor who founded the church and grew that church has a power and which is not checked, it often leads to all sorts of problems, whether it's monetary or it's the other way, and so on and so on. So it's wise to install a good system. And only by installing that good system, it's going to benefit overall to that group, which means immediate sacrifice to some, right? because nothing will ever satisfy everybody, everything. But installing the ecosystem is of great importance for the future of the welfare of that group. However, it's extremely difficult, you know why? Because of the immediate kind of thing. Who's going to really do it if it's not popular for those people who has to make the sacrifice now, right? So that's how it goes. Anyway. All right, so antitrust is coming from that aspect. Okay, now it becomes a major aspect where in any type of mergers and acquisitions of that type, right? If you are acquiring 20% or more of the shares of another company, then this automatically you have to check. It's a matter of just process where you have to check whether the threshold is met or not.